Can you see my slides? Whether you can see my slides or not?
So we can.
Oh, okay. Video is recording, right? Good afternoon. Now we're going to discuss about semiconductor integrated circuits layout design. So this is a sui generis act. So we will discuss what is the purpose of enacting this integrated circuit layout design act and what it will protect. And there are already existing IPs are there, intellectual property. Why it is not covering this, and what is the need of separate act, that we're gonna discuss here initially, and what are the requirements and what it protects, and what are the rights you're gonna get it, and what is the benefit of protecting integrated circuit layouts design. So we will discuss. So what are integrated circuits? Integrated circuits are commonly known as their chips or microchips, are the electronic circuits in which all the components, something like, inside IC, if you see in any mobile or any fridge or any watch, you can see the IC, integrated circuits. Inside, you can see transistors, diodes, and resistors, which have been assembled in a certain order on the surface of the thin semiconductor material. That is usually a silicon. So basically, I'm trying to explain what is IC, integrated circuits. You can find in even in the mobile, even in the TV, everywhere, you can find integrated circuits. Almost every electronic component. So what are the uses of IC, integrated circuits? In modern technology, integrated circuits are essentially elements for a wide range of electrical products, including articles of everyday use, such as watches, television sets, washing machines, and cars, as well as cars infotainment. There you can see ICs, as well as sophisticated computers, smartphones, and other digital devices. Everywhere you can find ICs, integrated circuit layout. So developing innovative layout designs of integrated circuits is essential for the production of ever smaller digital device with more functions. So if the device is very small, it is needed if you want to control it. So ICs will play into the picture. So we need to protect the layout design of a integrated circuits. Why we need to protect, we will discuss in next slide. Why does IC need protection? Creation of a new layout design requires an enormous investment and time from highly qualified experts. So if somebody has come up with IC, it takes some time for them to design that. So if there is no production, they will also copy the design of C. So that is called mask. You can get the mask of the ICs and you also can copy. So you no need to. So if you want, you need to protect it to stop this piracy. Like without your consent, somebody's copy, or this kind of arrangement is very much needed to design the integrated circuit layout, and we have to protect that. So copy is easy. So it is easy that everybody can copy. So maybe done by photographing each layer of an integrated circuit and preparing mask for the production of the integrated circuit on the basis of the photographs obtained. So how are you gonna copy this one? So it is very simple because as I discussed in integrated circuit, it contains transistors, diodes, and it is placed in a specific arrangement in such a way that you are generating some functionality. So this arrangement, if I can take the photograph and prepare the mask, and I also can copy the same thing. So the specific arrangement and getting the specific functionality that we need to protect to copy the piracy, to stop the copying and also to stop the piracy. In order to prevent unauthorized copying of layout design and to provide incentives for investing in this field, the layout design topography of integrated circuits is protected under a sui generis intellectual property system. What is sui generis? It is separately enacted because the arrangement of these diodes or in the integrated circuit layout, these resistors or diodes and all, they arrange in a specific way in such a way that they get that functionality. So if that is not protected, somebody else can easily copy, and they also come up with ICs. So in that way, if somebody is able to copy that, so the innovation and creativity cannot develop in that field. So that's the reason they have come up with a separate act where it can protect the design and as well as the along with the arrangement of the transistors, you will get some functionality also. So this kind of special, that means design and as well as the corresponding functionality, both you can see in integrated circuit layout design. So, and that is a three-dimensional design. So if you want to protect that kind of environment, so definitely you need a separate act, because in patents only you can protect the functionality. And if you take a design, industrial design, you can only protect the aesthetic appeal. There is no way you can protect the functionality. And if you can see the copyright, that is for literally artistic works, and that is basically for the expressions. So, but in coming to the semiconductor integrated circuit layout design, here the design is nothing but keeping the transistors and diodes in a separate arrangement in such a way that you get the functionality as well. So you need to protect the design, three-dimensional design, so which you cannot protect through industrial design, which we discussed in the previous class. And also you are getting some functionality out of that design. So that functionality you can protect through a patent, but patent cannot protect the design. So that is the reason we need a sui generis act, that means a separate act, that is a semiconductor integrated circuit layout design. So I'm just explaining that why we need to protect and why we need a separate act to protect the semiconductor integrated circuit layout design. So though we have the patent which can protect the innovation, design which can protect the aesthetic appeal, and copyright which can protect the expression, and trademark which can protect the reputation, goodwill, and brand, still we have a separate act. We need to have a separate act. Why we need, I'm explaining. So this is a three-dimensional design with functionality. So both the aspects we have to cover, which you cannot protect with the existing patent or design or copyright. So that's the reason we enacted a separate act. So why it cannot be protected under other IP laws? That is what I explained. That it not patentable as it does not involve an inventive step. See, in patent means higher functionality required. Inventive step means a lot of innovation is required. It covers the original design of a three-dimensional disposition. But when it comes to semiconductor IC layout design, it covers the original designs of three-dimensional disposition. The inventive step is not required. That much innovation is not required. Inventive step criteria is not going to satisfy. That's the reason we are not going for the patents, because it is a very high requirement. If you want to protect a semiconductor integrated circuit layout design through patents, you need to satisfy inventive step, which you cannot satisfy at all, because inventive step is for high category innovation. But in semiconductor integrated circuit layout design, that much high requirement is not needed. So that is the reason patents are not suitable to protect this IC layout design. And when it comes to industrial design, that also cannot be protected. Why? Because since they do not determine the external appearance of integrated circuits, but rather the physical location within the integrated circuit of each element with an electronic function. Design only it protects the aesthetic appeal only. It cannot protect any electronic function. And also some specific location you have to keep. That also it cannot be protected through industrial design. That's the reason we have come up with this Semiconductor IC Layout Design Act, as it cannot be protected through industrial design. And the third one is it cannot be protected through copyright protection, as it might be too general to provide a specific protection of layout design and related integrated circuits. I will explain in the next slide why the copyright is not sufficient to protect this IC layout design. Copyright law covers various creative works with minimal originality requirements. What is originality? Originality is nothing but it should be original from the creator. So creator with his own idea, he should create that. That is called originality. So minimal originality requirement is enough to protect a copyright, while semiconductor layout design protection demands higher originality standard for electronic component arrangements on chips. So bit higher originality. For example, you take a paper and you draw small diagram, and you can change bit and you can draw another diagram. So in that way, you can protect copyright for both the things, because minimal originality requirement is very minimal. But coming to the semiconductor layout design, it is not minimal. So it requires bit higher degree of originality, because you need to place the proper diodes and proper resistors. You have to keep in a specific location in such a way that you need to bring some functionality so that the IC will work. So the minimal originality requirement, which is there for copyright law, that is not sufficient, because bit higher originality requirement is there for semiconductor integrated circuit layout. That's the reason copyright is not through Copyright Act we cannot protect this IC layout design. And also copyright protection lasts the creator's lifetime plus 60 years. Normally, what is the, if you take a patent, it is 20 years from the date of filing. And if it is a design, it is the 10 years plus 5 years. And if it is take copyright, what is the protection for the copyright? Lifetime plus 60 years. But semiconductor chips have shorter protection due to their limited lifespan. So you no need to have these many years. That is another reason that we are not protecting through copyright. And also, unauthorized chip duplication is not copyright protected. If any unauthorized chip duplication is there, through somebody can take the photograph and some mask they can apply and they can copy. So these kind of unauthorized chip duplication is not protected through copyright. And the idea expression distinction is copyright can affect semiconductor layout design protection. What he is trying to say is copyright protects only expression. It cannot protect the idea, so, or functionality. So in the case of semiconductor integrated circuit layout, so with the arrangement of the diode, you are getting some functionality as well. So through copyright, no way you can get the functionality. You can protect the functionality. So considering all this, as you cannot protect this IC layout design through copyright or patent or design, we have come up with this act. So what are the international legal frameworks for this? So 1989, they have come up with the Washington Treaty on Intellectual Property in respect of ICs, integrated circuits, intellectual property integrated circuits, and it substantive provisions have been incorporated in the TRIPS agreement. So we need to remember what is the TRIPS agreement. TRIPS agreement are nothing but trade related aspects of intellectual property rights. So which is enforced through WTO, World Trade Organization. So World Trade Organization, where all the countries trade, almost all the countries in the world are members of WTO. So to have a ease of business, to smoothly transact between different countries, so there should be a common law with respect to the trade. So that has been enforced by using WTO through two set of packages. One is through GATT agreement, another one is TRIPS agreement. This is what I discussed in the last class. GATT agreement is general agreement on tariffs and trade, and TRIPS agreement is trade related aspects of intellectual property rights. Almost all the IPs, whatever, almost 7 or 8 IPs are there in India. So all the IPs should be compliant with the TRIPS agreement. Whoever is the members of TRIPS agreement, almost more than 153 countries, more than 160 countries in the world are members of WTO. They should comply with the TRIPS agreement. TRIPS agreement enforce, it's like a minimum set of criteria for each and every IP that they have to inculcate in their act. We are compliant at TRIPS agreement in 2005. So these are the provisions, Article 35 to 38. These are the provisions for TRIPS agreement. These provisions we inculcate in our act. What is our sui generis act? That is Semiconductor Integrated Circuit Layout Design. What I'm trying to say is TRIPS agreement is the basis. Every country in the world should inculcate in accordance with the TRIPS agreement. So the corresponding provisions for semiconductor integrated circuit layout is mentioned in Article 35 to 38. So this also we inculcate in our semiconductor integrated circuit layout. In most countries, a special law, that is sui generis law. Even in our country also, it is a special law, sui generis law on layout design, topographics of integrated circuit, or sometimes called mask works exist. So our country is also Semiconductor Integrated Circuit Layout Design Act, which is a sui generis law. An application for registration has to be filed in each country in which the production is served. So if you want to protect in a specific country, you need to file in that country because the right is the territorial. If you want to protect in other country, you need to file in other country as well, because the right that is given by Indian government, which is valid in India only. If you want to protect in another country, you have to file there. So what are the TRIPS provision for integrated circuit? As I said earlier, TRIPS is a trade-related aspects of intellectual property rights. Minimum set of standards that each and every country of the WTO. TRIPS is the agreement under WTO. So WTO, almost more than 155 countries are part of WTO. These all countries should compliance with the TRIPS agreement, so the trade will be smooth between the countries. That is the actual motive behind why this TRIPS agreement everybody signed, and we inculcate those laws, TRIPS agreement, into our act. So for integrated circuit layout, I said it is in Article 35 to 38, which is there in Part 2, Section 6 of the TRIPS agreement. Article 35 says that members must protect the layout designs of integrated circuits. Reason we are protecting and we are implementing the act. It has been approved by Parliament, and this act has came into the picture, and we are studying now. And IPIC treaty, also called a Washington Treaty. Initially, they have come up with before the TRIPS agreement, they have come up with the Washington Treaty, and whichever country is feel that this treaty should be part of this treaty, they can join Washington Treaty or IPIC Treaty, which is negotiated under WIPO, World Intellectual Property Organization, in 1989. So the purpose of Washington Treaty is aims to protect intellectual property rights related to IC. Before TRIPS agreement, actually I was mentioning all these things. So, but so many countries are not part of Washington Treaty or IPIC Treaty. Non-ratification issue, because the treaty has not entered into force due to insufficient ratification. So many countries are not ratified, not signed, and TRIPS agreement incorporates IPIC treaty, but TRIPS agreement WTO, so almost all the countries in the world are part of WTO. So through WTO, TRIPS agreement has been enforced. So in the TRIPS agreement, they mentioned whatever the provisions they have come up with through IPIC treaty or Washington Treaty, that information they included in the TRIPS agreement. That means we are in compliance with the TRIPS agreement, and TRIPS agreement contains Washington Treaty provisions. So Article 35 to 38 of TRIPS agreement also contains Washington Treaty provisions. So IPAC treaty or Washington Treaty provisions are protection term, treatment of innocent infringers. Integrated circuit layout, it is 10 years. Treatment of innocent infringers, application to infringing integrated circuit containing articles and compulsory license. All these provisions have been included in the TRIPS Article 35 to 38 through because we are compliant to TRIPS agreement that has been there in our act as well. So I'm just explaining what is the international jurisprudence or evolvement during the years and how it got into our act, sui generis act, which is a semiconductor integrated circuit layout design. So now when it comes to the act and the rule in India, the semiconductor integrated circuit layout design is, the act is 2000. So this became, the bill became act in the year 2000 and the corresponding rules are in 2001 for SICLD. Shortcut is Semiconductor Integrated Circuit Layout, SICLD. So what are the substantial definitions here? Layout design, which is defined in section 2H, means a layout of transistors and other circuitry elements and includes lead wires connecting such elements and expressed in a manner in a semiconductor integrated circuit. So in a IC layout, which is a silicon layout, where you are keeping transistors and other circuitry elements, then that is called a layout design. And when it comes to semiconductor IC, which is defined in section 2R, what does it mean? It means a product having transistors and other circuitry elements which are inseparably formed. So here the word is, you have to insist on inseparably formed. So in earlier definition, there is no inseparable. So on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic circuitry function. You keep these things in such a way that these means transistors and other circuitry elements in such a way that they are inseparable, and out of that arrangement you are bringing some circuitry, electronic circuitry function, then that is called semiconductor integrated circuit. So these two definitions are important. And what can be registered under this act? What is protected under this act? A layout design expressed in any manner. So if you want to protect under this design, these are the conditions you have to satisfy. It should be original. What is original? Original means it should come from the creator. So it should be original. It should not be copied from someone, or it should not be something like mixed up one, which has not been commercially exploited for more than 2 years from the date of application for the registration. So it should not be commercially exploited. So more than 2 years. For example, your creation is, layout design is, IC layout design is original. That means you have come up with 3-dimensional design, which is IC layout design, and also you have come up with functionality. But if it is already commercialized without filing it, if you commercialize, and if it is more than 2 years, sorry, they are not going to accept your registration. So before you commercialize, that means before you sell it to someone or before you ask someone to use it, better you file it. So if it is more than 2 years since you commercially exploited, it is not eligible for the registration. So, and the next one is, which is inherently distinctive and capable of being distinguishable from any other registered layout design, is protected or registered under this act. It should be distinctive. What is distinctive? Distinctive means the distinctive term is there even in the trademark as well. It should be unique. It should not look like similar to something, and capable of being distinguishable. It should not look like similar to something else. So it should be original. That means you are the creator of that semiconductor integrated circuit layout design, and you should not commercialize that. Before you commercialize, you have to file. Though you commercialize also, it should not be more than 2 years, and it should look distinctive. So it should inherently distinctive and capable of being distinguishable. So it should not look like similar to something else. It should clearly distinguish. So if that kind of design is there, then yes, this is registrable. That is what the act says. if these three conditions are satisfied, yes, you can register. And what can be registered under Semiconductor Integrated Circuit Layout Design Act? This is what I explained. Originality, the layout design must be original, meaning it should not be a copy of an existing design and should be a product of the creator's creativity. So you are not supposed to copy somebody's, or it should not be somebody's creativity claiming that it is your creativity. So you should not copy others. That is called original. So the layout design must be original. Then only it is eligible for the registration. And non-commercial exploitation, that means the layout design should not have been commercially exploited for more than 2 years, as I discussed, from the date of application for registration. This means that it must be relatively new and unused design. So if it is less than 2 years, still yes, it is acceptable. So it is not treated as a commercially exploited. And coming to the distinctiveness, the layout design should be inherently distinctive, which means it has unique and recognizable features. It should not be similar to the already existing one. There should be unique feature that it should be able to distinctive. Your design should be able to, then only it is registrable. And distinguishability. The layout design must be capable of being distinguished from any other registered layout design, which is already existed or which is already registered or which is already available. It should not match with that. So it should show distinguish, and it should be distinguishability character that you should show. It should not be confusingly similar to the existing registered design. If you can satisfy, yes, it is registrable. Who can file? A creator of a layout design and who has principal place of business in India. What is the principal place of business in India? So he might be having so many places, but principal place is in India. Principal place of business is in India. So he might be having business in some other countries as well. Maybe the headquarters might be in India, or if he does not carry out business in India, still he can file, provided he has a place of service in India, can apply for the registration. What is the place of service in India? Somebody is there to, so then also you can file. So basically they are providing the, if you don't have business also, still if you have some place of service, still you can apply for the registration. So basically they are trying to encourage the semiconductor integrated layout designs. So far we have very less IC layout design, because mostly this IC layouts are, our market is mostly like a software market, like service industry, and we are not a really a chip manufacturers. It's something like Korea or Japan or some US or some China or some uh, so these kind of countries are, they are very good in chip manufacturing. So India, especially during current government, is trying to promote IC layout design. So along with the service industry like software, we should come up with IC layout design also, like hardware also. So uh, in that way, there is a substantial role that this act will play. So there is a high chance that uh, hardware industry also we will start manufacturing in India soon. So that's the reason this act is having major role. So please pay attention to this. When to submit the application for registration? Once a company or an individual launches a new product with some unique feature, he or she or they or any company can submit application with a drawing or mask and layout of the circuit for registration. These two questions and corresponding answers are there in Semiconductor Integrated Circuit Layout Design website FAQ, frequently asked questions. You can see this, and other facts also you see for better information, more information. And what is the registration process cycle and time required for this? Filing of application by the creator of the layout design at the Semiconductor Integrated Circuit Layout Design Registry, that is the office. There you need to file the application. Whoever claims that he is the creator, original creator of the layout design, then he can file the application at the office. The acceptance of application, and register may accept or refuse the application or accept with some modification. So he might be having some objections. The accepted application shall be advertised within 14 days of acceptance. Why it is advertised, because if anybody want to oppose, they can oppose within 14 days. So any opposition to the advertisement can be filed within 3 months from the date of advertisement. Since from the date of advertisement, within 3 months, you have to oppose that, this is already, this design is already there, or this is your design, or this is already registered. If you have any grounds like that, you can oppose it. The computer statement, sorry, the counter statement to the notice of opposition, if any, to be filed within 2 months from the date of receipt of copy of notice of opposition from the registrar. So counter statement is, what is the counter statement? So if somebody files opposition to your design which you filed recently and which has been advertised, so if somebody files opposition, you can counter it, you can reply notice of opposition to him. So the timelines also mentioned, it's like something like 2 months. A copy of the counter statement provided to the opposition party. The registrar may take hearing with the parties and he will decide. Based on that, he will take the decision. Like opposition and then counter statement and then hearing, calling both the parties, and he will take the decision. Registrar will take the decision. The registrar will decide on the originality of the layout design and grant or reject the application for registration based on the conclusion reached by him. That is what I discussed. Aggrieved party can appeal to appellate board or in its absence civil court for relief on any ruling of the registrar. Imagine if he is not registrar decision is not justifiable and it is you become an aggrieved party, so you can appeal. So you can appeal the registrar decision. Rights obtained. What are the rights you can get it after the registration of semiconductor integrated circuit layout design? So from commercially using the protected layout design. So if you want to use commercially, which is already registered, you need to take the permission from, as he is having exclusive right to prevent others or stop others. This is a negative right. So if you register your semiconductor IC layout design, so you will get an exclusive right where with that you can exclude others from commercially using your design. So which is a negative right, you're gonna get it if you are a original creator and if you register it. The original topography cannot be reproduced entirely or partly for commercial purpose by others without the authorization of the right holder. So your authorization is needed. The protected layout design, an integrated circuit or an article which incorporates an unlawful reproduced layout design cannot be imported, sold or otherwise distributed for commercial purposes by others without the authorization of the holder of the right. For example, if you registered and you will get a exclusive, which is a negative right, so that you can prevent others, and also you can prevent somebody who is importing or who is selling or who is distributing. All this category of people you can stop, as you are having exclusive negative right. And also if they are doing this for any commercial purpose, yes, you can stop them, as you have the exclusive right and as you have registered under this act. Term of registered IC layout design is, it is 10 years from date of filing or from the date of first commercial exploitation anywhere in country, whichever is earlier. For example, if you commercially exploit in some other country, within 2 years, if you can file, still the registration is accepted as per the design, IC layout design registration procedure. So 10 years from the date of filing or from the date of first commercial exploitation. So within 2 years, date of commercial exploitation is accepted. So either this or that, you will get from that date 10 years. To obtain protection, any India or convention country citizen should have, what is convention? It's a Paris Convention. So almost 186 countries are members of Paris Convention, should have a place of business or address for service in India. So these people can protection and under section 3O of the Indian Patent Act, this is the Patent Act 1970, topography of IC is excluded or not patentable. So if any integrated circuit layout design, if they wanted to protect through our Patent Act, which is not allowed, which is not, which is mentioned in non-patentable subject matter of the section 3O under Indian Patent Act 1970. So the term of the registered IC layout design is 10 years from date of filing or from the date of first commercial exploitation. And this registration of IC layout design exclusively stopped or exclusively not patentable under section 3O of the Indian Patent Act 1970. So this is the two, these are the main information that has been covered in this slide. When a layout design cannot be registered, as I said, under section 7 of the Semiconductor Integrated Circuit Layout Design. So if that IC layout design is not original, and if it is commercially exploited anywhere in India or in a conventional country more than 2 years. So if it is less than 2 years, yes, it is acceptable. If it is more than 2 years commercially exploited, and then you are coming for the registration, yes, it is not registrable under SCIC, Semiconductor Integrated IC Layout Design Act. And also, if it is inherently not distinctive, yes, it is not acceptable. Inherently not capable of being distinguishable from any other registered layout design. So if these conditions are not satisfied, it is not registrable under Semiconductor IC Layout Design Act. And you need to remember that a registered semiconductor IC layout design not exploited commercially for more than 2 years from the date of registration of application shall not be treated as commercially exploited for the purpose of design. This is what I insisted in the last slide as well. So if it is more than 2 years, almost there is no chance that you can register your IC layout design under this act, as it bars exclusively. And what is infringement? If you, without the consent of the IC layout design creator who already registered under this act, and if you reproduce it or import or selling and distribute a registered IC layout design for commercial purposes, then it is treated as infringement. So a layout design created on the basis of scientific evaluation of a registered layout design shall not constitute any infringement. What is scientific evaluation? That means reverse engineering. Through reverse engineering, if you can come up with what exactly the layout design and what is the mask, and if you can come up with that, yes, it is acceptable. But if you can copy or if you can reproduce or import or sell or distribute commercially without any scientific evaluation, yes, that is considered as the infringement. So what are the remedies that has been given in this act? So both criminal and civil remedies are available. For example, if you take a patent, there are no criminal remedies, and design, there are no criminal remedies, but copyright and trademark and semiconductor integrated circuit layout design, yes, criminal remedies are there, and you will be sent to jail as well. So remember that for patent and design, only civil remedies are there. But criminal, yes, semiconductor integrated circuit layout design, copyright and trademark. So for the criminal remedies also available. So this line you remember, you make it in your MCQ in the exam. What are the infringement remedies under this statute? Infringing the rights of a registered proprietor of a layout design is punishable with imprisonment for a term that may extend it up to 3 years or fine not less than 50,000. That may extend it to 10 lakhs as well. Or with both you will get imprisonment as well as fine. Falsely representing a layout design as registered is punishable with imprisonment for a term that may extended up to 6 months or with fine which may extended up to raise 50,000 or with both. So you can, if you are representing that, yes, this is registered layout design, though it is not registered, that means that is falsely you are representing. In that case also, this fine and punishment or both might be applicable. So this is the website of IC Layout Design Act. Earlier it was under MITI, Ministry of Information Technology. department. Now it has come under DPIIT, Department for Promotion of Industry and Internal Trade, which is under Ministry of Commerce, Ministry of Industry and Commerce. So earlier it is under MIT, Ministry of Electronics and Information Technology Act. So these are the reference material. Thank you. If you have any questions, you can ask.